I think we need to have a constitutional reform in enlarging the time that we have in our constitution. 14 days cannot and will never be sufficient to address the concerns that we have as a country. But be that as it may, we have seen the invention of our judges. Remember, judges are actually expected to be Solomonic in the way they deal with the matters. And the directives that you're seeing from Anna Amadi, the registrar of the judiciary, I mean, these directives are actually informed by some wisdom, so that we can help in controlling the time that we use, or the timelines that are there. So that if you return back to the rulings that have also been made today, we have seen the admission of the office of the AG or the Attorney General as one of the parties. We have seen the admission of the Law Society of Kenya as an amicus, or rather, if you want, as a friend of the court. And one thing that is very interesting, if you read these rulings, is that the court has made mention that we shall only consider the brief, the amicus brief that has been written. So this is to mean that the Law Society of Kenya shall not be allowed to make oral admissions during the hearing of the case that has been filed challenging the declaration of William Samoei Ruto as the president-elect. Now, this in a sense should tell you this is a way of also saving on time. Remember, lawyers and pastors have one thing in common. They will tell you they will speak for 2 minutes. Then the 2 minutes become 20 and it becomes 1 hour. So in order for us to control, because you see judges also need to go and retire, they need to go and sleep, have some rest, so that they can come with a fresh mind to hear and also determine some of the issues that will be arising. If you read keenly through the petition that has been filed by the Right Honorable Raila Odinga, there is also the mention of he sought reliefs or prayers to be allowed to scrutinize some of the results from different polling stations, with the hope that he will get them in their favor and probably a declaration in his favor. So this should tell you that there is wisdom to determine some of these preliminary issues well in advance, because ultimately, if you read the Elections Act, particularly under Section 84, it tells us that the court can actually direct the IEBC to declare you the winner if, after a scrutiny or a retally, it is established that you actually won the elections, but there was an error during the declarations. So really, it is important that we have some of these preliminary issues decided before we get to the hearing of the main petition. So that at the main petition, there will be some discoveries that will be made at the interlocutory. And these discoveries at the interlocutory stage are the ones that are going to help the court in arriving at a just determination. Remember, the determination that should be made by the Supreme Court is not one that should be popular. Of course, the determination will either go in favor of Dr. William Samoei Ruto, or will go in favor of the Right Honorable Raila Odinga. So whichever way, we will find about 6 million of us will be uncomfortable about the decision, and another 6 million plus will be very happy about the decision that will come from the Supreme Court. So what is important is not a popular decision. What is important is for the Supreme Court or the court to arrive at a just determination, having considered every single material that is placed before it. So that if you ask yourself, I mean, with the bundles of documents, with the so many participants that are in these proceedings, will the court really have sufficient time? I know for a fact that the judges have assistants who help them during research and drafting and all those things. But really, it is not sufficient from where I sit that a decision of this magnitude should be handled or should be decided within a span of 5 days. Yes. So moving forward, probably when we have an opportunity of suggesting some amendments in our constitution, and I saw it even in the failed BBI attempt, that there was a proposal to expand the timelines of hearing and determining the presidential petitions. So it's a wait and see of what the future has for us as a country.
And now, Doc, looking at still on the IEBC, of course, in 2017, NASA then said we are not going back to the ballot if we have IEBC and the commissioners that are there. We have had issues of quorum. Do you remember during the BBI case? It's something that was very prominent in the High Court, the Court of Appeal, and also at the Apex Court. Let me jump the gun. The Supreme Court, a lot of people are expecting, and Kenyans are expecting, that only two decisions, either to annul or affirm. And if we have to go back to the ballot, I don't know how that will play out, because despite the fact that we have a divided commission, we also have trust issues. And it is the only independent commission that we have in the country. Doc.
Yes, those are the Solomonic areas that the courts have to look into, because you see, in the long run, you need confidence of Kenyans on the commission. And if the is divided, then the confidence will go down. You'll just still see the split coming out into four, and when that split come out into four, it will then, you know, dent into the credibility of the process again. So there will need to be a lot of wisdom, Solomonic wisdom, in the decision that the Supreme Court will have to come up with. And that's why I say that, you know, the decision will have to be one that looks at the peace and justice of today and the threats of tomorrow.
And still on the same, do you believe that we need to relook at the commission? Because we cannot only be having challenges when it comes to the presidential election. Absolutely, and I strongly agree with that. As a person who also was an observer within the bombers, there are many issues that I saw that need to be looked at in the commission. Some of them, you know, what we are seeing mainly are constitutional. There are a lot of operational issues that need to be dealt with at the corporate level. You know, for example, communication is a big problem for that commission. Right from beyond what you are seeing on the television, even how they were interacting with the journalists, you could see a lot of gaps that needed to be dealt with. And I think that this need for a lot of relook of the legal mechanism around it, and also the operational mechanism around the commission, if it really has to deliver its mandate objectively. Otherwise, we are still likely to see similar things happening. And, you know, if we are to go into an election, a rerun with the same, if we are to go into a rerun with the same commission as it is, then we are likely to have a lot of problems, because, you know, some of the parties will not want to accept it, and, you know, those are not the kind of things that we want to have. As we need a judgment that will bring confidence on Kenyans on the election, and also apart from that, apart from bringing confidence on Kenyans on the judges, a judgment that will also ensure that, you know, Kenyans get justice. If somebody won the election, he's given his win, and those who lost the election can also accept that they lost the election. So that relook will be very important to be undertaken by all those who will be involved. Council, let me bring in your comments on this, because at the end of the day, if we have to go to the ballot, of course, we have to also look on the other side, the IEBC. There has been so many questions that have been raised in regards to their operation, and also the public trust has been quite eroded. How do we go to the ballot, or we do expect, just exactly as you said, as you can see on your, just a minute, Council, as you can see on your screen, we have Professor George WAJACKOYAH, who was also in the presidential race, but now wearing a different tag and wig, for that matter, as a lawyer who, despite his campaigns and not even being one of the two, he has also been enjoined in the same. Council.
Yeah, I mean, it is something that is it's very interesting to see, because, you know, he's trying to show something. He is trying to show that, you know, I was into this race as a politician, but above that, I also believe in the law, and I want to ensure that, you know, my opinion as a legal expert is also expressed in this. So I think it is something that is very good, and we are yet to see how he will synchronize his political thought with his legal theory.
And Wamboi, if we have to go to the ballot, we still have IEBC, which is mandated by law to do that. But unfortunately, as I said, public confidence has been eroded. The numerous cases that have been filed against IEBC, a divided commission. Well, do we need the Solomonic advice from the 7 apex court judges so that we may know exactly what we do? Or do we have what, a caretaker committee if we have to go for a rerun?
Well, you know, the IEBC is a constitutional body. It's a commission that is created by the constitution with some autonomy. It has some independence. And when you look at the commissioners, you must look at them differently from an employee because they enjoy some constitutional protection. So that if you want to remove them or disturb their tenure in office, then there is an elaborate legal process that the law has put in place to ensure that they enjoy the protection. Remember, even after we are done with Chebukati, who should be retiring sometime in the month of January 2023, we'll have some other commissioners or other chairpersons who are not going to sit well with other individuals. So really, there must be some level of respect that we accord to their office, not necessarily even to their individuality. But even saying that, of course, I remain conscious to the fact that there has been an open display of disagreement between the commissioners. And I know too well that the Constitution also provides for mechanisms. Other than even running to courts, we have mechanisms that are put in place to ensure that we promote reconciliation, negotiations. So this is the time that our religious leaders should be taking the front row seat, so that they can broker an agreement between some of these the commissioners that are fighting, or we are seeing them to be fighting. So really, what is important?
And as you can see, just a minute, Wambui, as you can see, those are some of the lawyers that will be battling it out in the Supreme battle today. I've seen Senior Counsel Philip Mugo, and we have seen, he's the one who was standing slightly a couple of meters just outside the court. And also, as you can see on your left, is a ceremonial hall at the Supreme Court that will play host to the case. And 10-15 minutes ago, it wasn't as busy as it is now. So we're expecting the judges to keep their time at exactly 11, as they had talked about also in the presser and also in the press release that they just issued yesterday. Allow me now to bring in yet another constitutional lawyer, Henry Kurauka. Karibu sana, Counsel.
Thank you very much.
In a nutshell, we've been talking about the Solomonic decision that we expect in just 5 days, and we haven't started the case yet. I would like to pick your I'll pick your mind on that as we rectify that on how all these things we're expecting it to pan out. And Wamboi was touching on what we can do as a country, because if at all the apex court decides that we will have to go back to the ballot, we don't have a choice. We have to go back to the ballot. But unfortunately, on the other hand, we still have a lot of housekeeping to do at the IEBC. Counsel, you had not finished your sentiments on what we are supposed to do as a country. Are we supposed to get maybe a caretaker committee? Because we have to do that as enshrined in law in 60 days. We cannot sort out all the IEBC mess in that time and hold a rerun in that time as well.
And I will still insist that I know it is not constitutionally possible to have a caretaker commission. Remember, and I have made mention of this, the commission is a creature of the Constitution. It borrows its power and authority from the Constitution. So if you want to come up with a caretaker committee, you cannot do that without amending the Constitution as we know of it today. So but my only emphasis is that we need to have some brokers of peace. So that our religious leaders, we have our political leaders, and we have, we have ambassadors, we have people from all walks of life. You remember it took the hand of Kofi Annan in the year 2007 to just come and at least help us in reconciling ourselves. So I think most importantly, we need to reflect on the importance of our office and the importance of what we do in our offices in the future, so that we can just get away, or we can just refuse or decline the distractions that we are seeing from this petty politics that we have been seeing. Yes, but yeah. I think that is the only thing that moving forward we can help in salvaging the situation. Otherwise, we'll have just an anarchy or some level of lawlessness moving forward up until when some of these 3 commissioners who should be retiring in January are out of office, which is not constitutionally possible, because in the event that we have a rerun, we have a repeat election, it should be done within 60 days, and 60 days will not take us to January. So we'll still have the 7 commissioners, uncomfortable as they are finding themselves, still in the same office.
Okay, Kurauka, your sentiments on the same?
Thank you very much. My views are as follows. I do expect only 2 outcomes from the Supreme Court. The first outcome is validation of the elections, in which Dr. Ruto will be sworn in on 13th of September. The other outcome that we expect is invalidation of the elections. Once that is done, we must have fresh elections within 60 days. Now, our constitution does not limit the number of elections that our Supreme Court can invalidate. So it can go on and on and on until 2027.
That's an interesting way to look at it, because you're talking about if we go for a repeat election and somebody raises the same petition at the Apex Court, we can just keep on.
It's a separate election. It must comply with the law. And the Constitution allows the Supreme Court to do what it is supposed to do. When the petitions were filed, in my view, President-elect status was frozen, because he cannot be sworn in until the Apex Court makes a decision. On the issue of our people, the Kenyans, we have now matured. We are not ready to fight each other over elections. I'm so happy that we have had very peaceful elections. And my appeal is to religious leaders, stakeholders, the people of Kenya, to uphold the peace we have enjoyed. Because at the end of the day, we have a country that belongs to each one of us. Now, to our leaders, we have many leaders who have been elected. Kindly uphold the core values. Act in good faith for the interest of Kenyans, and we shall have a very peaceful country, whichever way the judges rule. And we have a lot of confidence with our judges. All of them are men and women of great integrity and legal minds. Finally, I would like to say that the problem in Africa is that Africa is full of graveyard of wonderful laws, wonderful constitutions. But when it comes to leadership, we have issues with many leaders, and that's where the confidence has really gone down, whereby leaders do not want to act in good faith and for the interest of the common man, so that we ensure cost of living is down and leaders are there to core values, integrity, honest, corruption-free, and so on. Therefore, as a constitutional lawyer, I wish to call upon Kenyans to be peaceful, to accept whatever results comes from the Supreme Court, because it is the final arbiter in this dispute. As to the merits of the petitions, we cannot discuss now, but we have faith in our Supreme Court. Thank you.
And Doc, back to you. Council Kurauka has talked about how we have very good laws, but unfortunately we have dumped them in a graveyard. But away from that, he has also mentioned about we have always mentioned about the Solomonic the decision that we are waiting by the 7 judges, Martha Koome, Philomena Mwilu, Smokin Wanjara, Mohammed Ibrahim, Joaquin Rungu, and also the latest to join the fray, that is William Ouko. But it is the first time that the CJ is having this petition on the bench. It is also the first time for William Ouko. And it is now constituted 7 judges as opposed to what we had in 2017. What level of sharpness should they be? Because this is quite a unique petition.
Yes, I think that the beautiful thing is that these are people who have had experience within the judiciary, and I'm sure that they have had a glimpse of cases around petitions, not necessarily of presidential nature, but maybe of other caliber. And so they have served previously within different locations, different positions in the judiciary. So this really, that wealth of experience is going to be of significance for them as they make this judgment. And the beautiful thing about this is that I think for the first time you're having a lot of these. Of course, the petitions even previously were in the public opinion, but in the public domain. But you are seeing a lot of affidavits, being in public domain, and so the court of public opinion are also making their own judgments. So there's a lot of things that the judges have to look for. So in as much as they're going to look at, we are talking about the Solomonic wisdom, yes, but then it's just because the law is also there that gives them the framework upon which to make certain decisions. But then the law is not like 1 + 1 is 4. Okay, it's not like mathematics that is very definitive. It will give you the framework, but then you have to make decision within that framework so that it becomes justifiable. And so it is within those that it is out of that indefinite that then brings in the idea of judges, the need for judges to look at situations and come up with the Solomonic judgments at any given time. And for me, I still believe that this petition at this time is not just for today, and we need to look at it beyond a win or a loss of an election and see the possible threats that our country faces for the future. Because we can be so focused on today until we forget tomorrow, and then when tomorrow comes, we wish that we should have looked at this before.
Council, Doc is talking about this being quite a Solomonic decision that they have to make. And not only will it cater for today, but also cater for tomorrow. Looking at the current jurisprudence, we had a big one in 2017 when the elections were annulled. We also had a big one when the BBI also went to the drain. Now we have even judges and observers from outside. And the 2017 decision was hailed by many countries as quite a decision, and a bold one for that matter. Now we are in the same position again. The decision of these judges, what does it speak of the current jurisprudence that we have in the country based on what we've had in the last couple of, let's say even in the last 2 years, because we've had the BBI, which also went all the way to the apex court. Now we also have an election petition. Actually, many petitions for that matter.
Well, Joe, I agree with Daktari here that indeed the task that lies ahead of the 7 Supreme Court judges is quite, it's a big task that should not only look at the present, but should have a keen look at the future. Remember, the Supreme Court is just a unique court that was formed after we promulgated the Constitution. Previously, the Court of Appeal was the highest court on this land. But the Supreme Court, if you read the Supreme Court Act, it has some special jurisdiction or objectives. It has some objectives that it must fulfill every time it makes a decision on any issue. Number one, it must ensure that there is indigenous growth of our law. That, of course, course, focuses also on our past. It looks at our history as a country. So that any decision that the Supreme Court comes up with must first be informed by our history as a country. And perhaps when you had the opportunity of discussing, the fall of the BBI decision, you saw there